Hello and welcome to the Week 2 online lecture for LWS011 Journalism Law. I'm Peter Black. The topic of this week's lecture is all about free speech and freedom of the press, which, as you can imagine, is very relevant for a unit such as journalism law. So what we're going to do today is to have a little bit of an introduction to what is meant by the concept of free speech, including the philosophical justifications of free speech, and then we're going to look at how freedom of speech is protected under the law, both at an international level as well as in Australia. And we'll conclude by looking at some of the modern challenges to free speech. So let's begin with this extract from Pearson and Polden. They write that journalists are sometimes called upon to defend press freedoms against those who are critical of the media and its operations. To remain silent when a politician or judge is proposing censorship of those freedoms is to contribute to their erosion. It is important that journalists have a grasp of the principles of press freedom and their historical context. I think this makes a lot of sense. The principles of free speech indeed lie at the heart of media regulation in Western liberal democracies such as Australia. And so you need to be able to understand some of those underpinnings to appreciate how media regulation works. But there's also just that more important and higher principle that journalists who are sometimes called upon to defend press freedoms need to be able to make those arguments. And so this lecture is also about developing your understanding and building up your construction of some of those arguments. Now, in this online podcast, you'll note that some of the expressions like freedom of speech, freedom of expression, and freedom of the press are all related concepts, and they will sometimes be used interchangeably. Now, as we move throughout this online lecture and also throughout the reading in the textbook, I would encourage you to think about these few questions. First, should freedom of speech be absolute, and why or why not? And then secondly, what limits, if any, would you place on freedom of speech in Australia? I'll invite you to pose your answers to this question, both on the discussion board, but we will also talk about them during the face-to-face workshop. So now let's begin to look at what we mean by free speech. Now, speech, we probably all think we know what that means, but it's relevant to appreciate that it can take a number of different forms. Speech with factual content, that is information. Speech with normative or moral and ethical content, including political discussion and opinions. And then also speech with expressive content, especially artistic works or acts of self-expression. Speech with expressive content doesn't necessarily have to be contained in words. It can be done using your body or simply by being present in a particular space. And it is also relevant to appreciate that these categories, that is speech with factual content, speech with normative or moral ethical content, and speech with expressive content, may overlap in a given case. Now, the regulation of the Australian media has its heritage in the law of England. We saw this last week when we were just looking at the evolution of the Australian legal system itself. We took a great deal from Great Britain, and so it's no surprise that when we're talking about regulation of the media, we also share a great deal with the law of England. As such, the development of press freedom in England is relevant for the law and politics of free speech in Australia today. And really the turning point here for free speech was the invention of the printing press. That really was the single event that revolutionized the notion of both freedom of speech and also regulation of the media. What we also saw in Great Britain was the fact that they moved from a monarchy to a parliamentary system in the 17th century, and ultimately the rise of parliamentary democracy in the 18th century. And the notion of a free and vibrant press is important to all of those historical developments and very much underpin the sort of media regulation that we saw in England and that we also see today in Australia. So why is free speech important? Well, there are usually three main justifications put forward in favour of some sort of protection of freedom of speech or freedom of the press. These relate to speech and autonomy, speech and truth, and then speech and democracy. And so we're going to take just a moment to look at each of these three justifications in turn. The first justification is speech and autonomy. The argument here is that speech enhances individual autonomy, largely because speech is a uniquely human activity. Now, Scanlon argues that because autonomous humans have a right to make up their own minds, they also have a right to all the information that is necessary for them to do that. And for, therefore, individuals to make decisions as they go about their daily lives, there needs to be an element or a component of free speech to give them the information that they need to make up their minds as they go about their daily lives. So that's the rationale on the basis of autonomy. The next one is that of speech and truth. This is one of the more commonly cited justifications for freedom of speech. The argument here is that there is value in speech for the discovery of truth, and this is truth in its widest sense, not just information, but it also includes political or ethical truths. Now, the notion of speech and truth has been articulated and espoused upon by several leading thinkers and philosophers, including Milton, who wrote that, "And though all the winds of doctrine will at loose to play upon the earth, so truth be in the field, we do injuriously by licensing and prohibiting to misdoubt her strength. Let her and falsehood grapple. Whoever knew truth put it to the worse in a free and open encounter." So the idea here is that you want the clash of ideas between truth and falsehood, and that we only begin to truly appreciate truth when we have that free and open encounter between truth and falsehood. Similarly, John Stuart Mill, in his classic tome on liberty, wrote that every opinion which embodies somewhat of the portion of truth in which the common opinion omits ought to be considered precious, with whatever amount of error and confusion that truth may be blended. And then finally, Justice Holmes, in the case known as Abrams versus the United States, where His Honour said that the best test of truth is the power of the thought to get itself accepted in the competition of the marketplace. So this is the idea of the marketplace of ideas. You want these ideas competing and wrestling and struggling with one another, and that it is only through that tussle that we get to discover the truth. The next justification is speech and democracy. This justification is derived from the democratic structure of societies. The notion here that if there are no restrictions on the speech which can be exchanged in the body politic, then the outcome will be a healthier and more pure democracy. Now, one of the most notable proponents of the link between freedom of speech and democracy is the US philosopher Alexander Meiklejohn. He argues that the concept of democracy is that of self-government by the people, and that for such a system to work, an informed electorate is necessary. And in order to be appropriately knowledgeable, to be appropriately informed, there must be no constraints on the free flow of information and ideas. So the rationale behind this justification in terms of speech and democracy is that speech is essential for democracy, for self-government by the people to indeed operate. So, by way of introduction, that then gives you some of the philosophical underpinnings behind freedom of speech. Let's now actually look at how free speech is recognised internationally. Now, at an international level, it's recognised in a number of international standards, including Article 19 of the International Covenant on Civil and Political Rights. You see there in Clause 1 that it says everyone shall have the right to hold opinions without interference. In Clause 2, everyone shall have the right to freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers, either orally, in writing, or in print, in the form of art, or through any other media of his choice. But, and this is where it's become very important, there is there in Clause 3 a qualification. It says that the exercise of the rights provided for in paragraph 2 carries with it special duties and responsibilities. It may therefore be subject to certain restrictions, but these shall only be such as are provided by law and are necessary, A, for respect of the rights or reputations of others, and B, for the protection of national security, or of public order, or of public health and morals. So you see here, even in the International Covenant on Civil and Political Rights, that there is a limit placed upon free speech. It's not absolute. Now, in addition to what is provided for internationally, a number of countries also have protections for freedom of speech. The United States protects free speech in their First Amendment to the United States Constitution, and we'll talk about that in a moment. But a number of other major democratic English-speaking nations also have bills of rights that enshrine free speech. So in Canada, they have a Charter of Rights and Freedoms. In the UK, there is the Human Rights Act, and in New Zealand, there is a Bill of Rights. However, many countries justify stricter regulation of speech and media freedom on religious, cultural, or economic grounds. We're going to take a moment now to look at the United States perspective, where they have a constitutional protection for free speech in their First Amendment. The First Amendment to the United States Constitution relatively provides that Congress shall make no law abridging the freedom of speech or of the press. So this is a constitutional protection, an explicit constitutional protection for both freedom of speech and also a free press. What this means is that the United States has developed a very strong culture, both legal and social, surrounding freedom of speech. And the US government has various attempts of the US government to restrain publications in national interest usually fail on First Amendment grounds. So what are the main characteristics of First Amendment jurisprudence? That is to say, what are the main characteristics of the way in which the court has interpreted this First Amendment? A few things to note. First of all is that the First Amendment covers more than just speech per se. It also covers symbolic speech. So, for example, flag burning. No words are said, but that's a symbolic gesture that has great speech value. So it's wider than just words. Most First Amendment action is about protecting limitations imposed by the state, that is, by governments. Usually when we talk about free speech, at least in a legal context, we are not so much concerned about what private individuals or businesses or organisations are doing. We are concerned about what restrictions the government may be placing upon speech. But even though the United States First Amendment contains quite a strong protection on free speech grounds, it is not an unlimited protection. It is not absolute. So limits may be justified by a substantial state interest. But laws that limit speech, usually on the basis of its content, are indeed struck down. So let's just look at a few of the landmark cases out of the United States. An important decision for press freedom came in the case of Lange and Minnesota, in which the Supreme Court of the United States rejected what is known as prior restraint. Prior restraint is pre-publication censorship, so whereby something is not even able to be published. Now, in this case, the Minnesota legislature had passed a law that allowed courts to shut down malicious, scandalous, and defamatory newspapers, allowing a defense of truth only in cases where the truth had been told with good motives and for justifiable ends. The court held that this law was unconstitutional and therefore invalid. The court basically said that prior restraint, this form of pre-publication censorship, is only allowable in extreme circumstances, such as the proposed publication of obscenity, incitement to violence, or national security. Another landmark case that gets referred to quite a bit, especially these days in the era of WikiLeaks and Edward Snowden, is the case known as the Pentagon Papers case, New York Times Company and the United States. In that case, the administration of President Richard Nixon sought to ban the publication of the Pentagon Papers, which were classified government documents about the Vietnam War that had secretly been copied by analyst Daniel Ellsberg. The court held that the government had not met the heavy burden of proof required for prior restraint. Justice Brennan wrote that only governmental allegation and proof that publication must inevitably, directly, and immediately cause the occurrence of an evil kindred to imperiling the safety of a transport already at sea can support even the issuance of an interim restraining order. A number of other justices, including Justices Black and Douglas, went further, writing that prior restraints were never justified. So again, very hard for the government to engage in any form of prior restraint or pre-publication censorship here. Perhaps, however, the most significant First Amendment case in recent decades was the New York Times and Sullivan, which was a defamation case. This case resulted in the court ruling that public officials had to meet tough new tests before they could succeed in a defamation action, even if the allegations in the article were proven false. So in that case, an advertisement was published in the New York Times indicating that officials in Montgomery, Alabama had acted violently in suppressing the protests of African Americans during the Civil Rights Movement. The Montgomery Police Commissioner Sullivan sued the New York Times for libel, stating that the advertisement damaged his reputation. The court unanimously overturned the judgment and concluded that this did not amount to defamation. Public officials may only sue for libel if the publisher published statements in question with actual malice, knowledge that it was false, or with reckless disregard of whether it was false or not. Now, as we'll see, that is not the test under Australian defamation law, but that is what is required under American defamation law because of the protection that is provided for free speech by the First Amendment. Now let's compare the American situation with the legal situation here in Australia. Unlike the United States, Australia doesn't have an equivalent of the First Amendment in our Constitution that enshrines freedom of the press. Indeed, the Founding Fathers deliberately included very few express rights and freedoms in the Constitution. This observation was made by High Court Judge Justice Dawson in a case known as Kruger and the Commonwealth. His Honour said that the Australian Constitution, with few exceptions and in contrast with its American model, does not seek to establish personal liberty by placing restrictions upon the exercise of governmental power. Those who framed the Australian Constitution accepted the view that individual rights were on the whole best left to the protection of the common law and the supremacy of Parliament. Thus, the Constitution deals, almost without exception, with the structure and relationship of government rather than with individual rights. The fetters which are placed upon legislative action are, for the most part, for the purpose of distributing power between the federal government on the one hand and state governments on the other, rather than for the purpose of placing certain matters beyond the reach of any parliament. The Constitution does not contain a Bill of Rights. Indeed, the 1898 Constitutional Convention rejected a proposal to include an express guarantee of individual rights largely based upon the 14th Amendment to the United States Constitution and including a right to due process of law and the equal protection of laws. The framers preferred to place their faith in the democratic process for the protection of individual rights and saw constitutional guarantees as restricting that process. Thus, the Constitution contains no general guarantee of the due process of law, nor does it contain any guarantee for freedom of speech. Interestingly, when we look at the text of the First Amendment to the United States Constitution, it does contain a protection there for freedom of religion, which was reproduced almost word for word in the Australian Constitution, section 116. However, there is no explicit, express constitutional protection for free speech in the Australian Constitution. That said, while the High Court has accepted that the Constitution contains few express rights and freedoms, they have recognised that the system of representative government created by the Constitution gives rise to what is described as an implied freedom of political communication. So we don't have anything that expressly protects free speech, but the court has looked at the Constitution and said that there is an implied freedom of political communication. Now, while this implied freedom of political communication is now an accepted feature of Australian constitutional jurisprudence, it remains quite controversial, and a few questions remain or persist about its ambit. Now, what are some of the key features then of this implied freedom of political communication? The first is that it is an implication derived from the text and structure of the Constitution. In particular, the fact that our Constitution puts in place a system of representative and responsible government. It relates to communication on government and political matters. It's not a wider free speech right that protects any form of speech. It is speech related or communication on government and political matters. So it protects political discussion in relation to all levels of government, federal government, state level, and also local government, and it is not absolute. There are limits on it. Now, the origins of the implied freedom of political communication can be found in some cases going back to the 70s and 80s, but the two key decisions that found that this implied freedom of political communication exists were Australian Capital Television and the Commonwealth and also nationwide news and wills. So let's look at what was going on then in each of these cases. In Australian Capital Television Proprietary Limited and the Commonwealth, they were concerned with some amendments to the Broadcasting Act. Relevantly, the Political Broadcasts and Political Disclosures Act inserted a new part into the Broadcasting Act. Part 3, capital D, introduced a ban on electronic broadcasting of political advertising during election periods and required broadcasters to make available free time for election advertising by political parties, as allocated by the Australian Broadcasting Tribunal. The majority, with 6 justices agreeing, 1 dissenting, held that the Constitution contained an implied freedom of communication on political matters, which was required by the system of representative democracy provided for in the Constitution. So let's have a look then at a few of these judgments. Chief Justice Mason said that, absent such a freedom of communication, representative government would fail to achieve its purpose, namely government by the people through their elected representatives. Government would cease to be responsive to the needs and wishes of the people, and in that sense would cease to be truly representative. Justice McHugh similarly said, when the Constitution is read as a whole, and in the light of the history of the constitutional government in Great Britain and the Australian colonies before Federation, the proper conclusion to be drawn is that the people of Australia have constitutional rights of freedom of participation, association and communication in relation to federal elections. So, the court in ACTV, also known as the Australian Capital Television, found that there was this implied freedom of political communication and invalidated these laws as a result. Another case handed down on the exact same day was Nationwide News Proprietary Limited and Wills. That case dealt with a section of the Industrial Relations Act which made it an offence for any person to use words calculated to bring a member of the Industrial Relations Commission or the Commission itself into disrepute. The defences which were ordinarily available to persons charged with such an offence, such as fair comment or honest and reasonable mistake of fact, had been removed. The court held here that this prohibition was unconstitutional on the basis that it violated the implied freedom of political communication. Now, relevantly, look at the statement of Justice Brennan. His Honour said that where a representative democracy is constitutionally entrenched, it carries with it those legal incidents which are essential to the effective maintenance of that form of government. Once it is recognised that a representative democracy is constitutionally prescribed, the freedom of discussion, which is essential to sustain it, is as firmly entrenched in the Constitution as the system of government which the Constitution expressly ordains. Similarly, Justices Dean and Toohey said that the doctrine of representative government presupposes an ability of representative and representatives to communicate information, needs, views, explanations, and advice. It also presupposes an ability of the people of the Commonwealth as a whole to communicate among themselves information and opinions about matters relevant to the exercise and discharge of governmental powers and functions on their behalf. It follows from what has been said above that there is to be discerned in the doctrine of representative government which the Constitution incorporates an implication of freedom of communication of information and opinions about matters relating to the government of the Commonwealth. So these two very important cases, ACTV and Nationwide News, established that there was an implied freedom of political communication in the Australian Constitution. The implied freedom of political communication was expanded in a series of subsequent cases, including Theophanous and also Stevens and West Australian newspapers. And although Theophanous and Stevens mark the zenith of the implied freedom of political communication in terms of the scope of it, in both of those cases quite a bit of division emerged amongst the courts. And so what we saw then was in a case known as Lange and the Australian Broadcasting Corporation, in a rare, unanimous joint judgment, all 7 justices of the High Court wrote together and clarified the scope of the implied freedom of political communication. So let's now focus on the current scope of the law as set forth in Lange and the Australian Broadcasting Corporation. Now, in that case, the plaintiff, a member of the New Zealand Parliament and a former Prime Minister of New Zealand, brought a defamation action against the ABC alleging that he had been defamed during a Four Corners program. The court held that the Constitution conferred no private right of defence, but instead created an immunity against legislative incursion into free communication in respect of political matters. So the court expanded the common law defence of qualified privilege to provide a protection for the criticism of politicians, which is something we will look at when we consider the defences to defamation in a few weeks' time. The court also took the opportunity to settle several of the disputed questions arising from their earlier decisions. So, these are the general principles that we can take away from Lange. First, freedom of communication on matters of government and politics is an indispensable incident of the system of representative government which the Constitution creates. In particular, Sections 7 and 24 of the Constitution and related provisions necessarily protect that freedom of communication between the people concerning political or governmental matters which enables the people to exercise a free and informed choice as electors. The freedom is not confined to an election period, and the freedom is not absolute. It is limited to what is necessary for the effective operation of the system of representative and responsible government. So, what the High Court said in Lange was that in order to determine whether a state, federal or territorial law is valid, two questions must be answered. First, does the law effectively burden freedom of communication about government or political matters either in its terms or its effect? Then if you answer yes to that first question, you move on to the second question, which is if the law effectively burdens that freedom, is the law reasonably appropriate and adapted to serve a legitimate end, the fulfilment of which is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. This basically remains the correct test, a minor alteration made by the court in the case of Coleman and Power. So, what was going on then in Coleman and Power? Coleman was protesting in Townsville. He was distributing pamphlets which contained charges of corruption against several police officers, including Power. Power had approached Mr. Coleman and asked to see a pamphlet. Coleman pushed Power and said loudly, "This is Constable Brendan Power, a corrupt police officer." The magistrate who dealt with the case said that the appellant was not protesting against any laws or government policies, but was conducting a personal campaign related to particular officers of the Townsville Police. Although there was a dispute as to the precise sequence of events, the prosecution case against the appellant, which was substantially accepted by the magistrate, was that the pushing and the verbal insults were intended to provoke an arrest. Coleman was convicted of using insulting words in a public place contrary to the Vagrants, Gaming and Other Offences Act. The court held that Coleman's conviction for using insulting words should be set aside. The majority said that the relevant provision of the Vagrants, Gaming and Other Offences Act was either unconstitutionally invalid or should be interpreted in a manner that did not capture Coleman's conduct. So the general principles that we can take away from Coleman and Power are as follows. First of all, a majority of the court held that communications alleging corruption by state police were capable of protection under the implied freedom of political communication. The court also accepted that political communication could include insults. Note, in particular, the judgment of Justice Kirby at paragraph 239, where His Honour said that from its earliest history, Australian politics has regularly included insult and emotion, calumny and invective in its armoury of persuasion. Anyone in doubt should listen for an hour or two to the broadcasts that bring debate for the federal parliament to the living rooms of the nation. The majority of the court also slightly reformulated the test from Lange. So it now is as follows. In order to determine whether a state, federal or territorial law is valid, two questions must be answered. First, does the law effectively burden freedom of communication about government or political matters either in its terms or its effect? And secondly, if the law effectively burdens that freedom, is the law reasonably appropriate and adapted to serve a legitimate end in a manner which is compatible with the maintenance of the constitutionally prescribed system of representative and responsible government? That is to say, that both the end and the manner of achieving the end must be compatible with the maintenance of the constitutionally prescribed system of representative and responsible government. Let's now look at some of the cases that have applied these tests from both Lange and the ABC and also Coleman and Power. To begin with Levi and Victoria. Levi was an animal rights activist who'd been charged with summary offences under Victorian hunting season regulations, which made it an offence for people who did not hold a valid game licence to enter into or upon any permitted hunting area during a specified period of time. During this period, licensed hunters were allowed to shoot and kill ducks. The plaintiff, who did not hold a licence, challenged the constitutional validity of the regulations on the basis that, among other things, the regulations were unconstitutional by reason of the implied freedom of political communication. Now, this case is significant for two reasons. The first is the fact that it held that speech is not just limited to verbal speech, it covers non-verbal forms of communication. And so they concluded here that yes, this did place a burden on political communication, so it satisfied the first step of the two-step test, but it did not satisfy the second step. They held that these regulations were valid as they were reasonably appropriate and adapted to securing a legitimate end, that being the protection of public safety. Another case is Appler and the Legal Services Commissioner. Here it was held that advertising legal services was not a political communication. More relevantly, then, perhaps, there is Hogan and Hinch. Now, Darren Hinch challenged his conviction under a law prohibiting the naming of sexual offenders who are being released into the community under extended supervision orders. The court held that restricting publication of names of sex offenders is not political communication, and therefore this freedom did not apply. In Wotton and Queensland, Lex Patrick Wotton was charged with inciting a riot on Palm Island following the death in police custody of Doomadgee. He was convicted, and on his release, his parole condition stated that he was not allowed to speak to the media and needed to gain permission before he could attend public meetings on Palm Island. Wotton challenged the constitutional validity of these laws. It was held that the laws authorising the restrictions on interviews by the parolee was valid. There was a legitimate end here of community safety. Monis and the Queen was the next case. Monis and another sent letters to relatives of deceased soldiers convicted of using a postal service to harass them. It was held that this did affect his freedom of communication, but there was a 3-3 split on the court as to whether it was proportionate to a legitimate end, and so it confirmed the decision of the New South Wales Court of Appeal and rejected the appeal. It was also been the case of Attorney General of South Australia and the City of Adelaide. Street preachers had been convicted of haranguing people in a public place. It was held that the laws were valid. Most preaching was not political speech, and in any event, the law was promoting a legitimate purpose of peace in the streets. And then lastly, and importantly, unions of New South Wales and New South Wales. In this case, a New South Wales law imposed caps on political donations, as well as election expenditure by political parties. It also mandated public reporting requirements to allow for public scrutiny and transparency in the funding of political parties. 2 amendments passed in 2012 went further. First, a new section was introduced into the Election Funding, Expenditure and Disclosures Act. It prohibited political donations by persons who were not on the New South Wales electoral roll. Hence, donors could not be corporations or trade unions or foreigners. Second, it was provided that the electoral communication expenditure of political parties and their affiliates was to be aggregated for the purposes of caps. Affiliation was defined by reference to bodies that can appoint delegates to the governing body of a party or participate in pre-selection of candidates for that party. In this way, it only affected the Australian Labor Party. The court held unanimously that those sections were invalid on the grounds that they impermissibly burdened the freedom of communication on government or political matters. So, that hopefully gives you a snapshot of the relevant case law dealing with the implied freedom of political communication. But it is important to appreciate that it is only an implied freedom. It's not expressly provided for in the Constitution. We don't have a National Bill of Rights. There are, however, now some states that do have a Bill of Rights. So, for example, in the ACT, Section 16 of their Human Rights Act provides that everyone has the right to hold opinions without interference and that everyone has the right to freedom of expression. Similarly, Section 15 of the Charter of Human Rights and Responsibilities Act in Victoria provides that every person has the right to hold an opinion without interference and that every person has the right to freedom of expression. It does, however, though, in section 15.3, place some limitations upon that. It says special duties and responsibilities are attached to the right of freedom of expression, and the right may be subject to lawful restrictions reasonably necessary, A, to protect the rights and reputation of other persons, or B, for the protection of national security, public order, public health, or public morality. As I said, we don't have a national Bill of Rights, nor do we have a Bill of Rights here in Queensland. Now, as you would expect, there are some modern challenges to freedom of expression and press freedom. The war against terrorism, internet censorship, and threats to press freedom from within the media are all relevant here. But freedom of expression has always been rejected as being an absolute freedom. There were always limits on it. And so we'll end this online lecture podcast as more or less we began, with these two questions. But I would encourage you to contribute to the discussion board in relation to, and also talk about in the face-to-face workshop. So think about it. Should freedom of speech be absolute? Why or why not? And what limits, if any, would you place on freedom of speech in Australia? That then is the end of this week 2 podcast on free speech. Thank you.